This is Duke University.
How are you? This is a celebration of the publication of a new book, Human Rights and Intellectual Property, Mapping the Global Interface, by our dear colleague Laurence Helfer and his co-author Graeme of the Victoria University of Wellington. I'm really grateful that you could come. This is an event which is sponsored by the Center for the Study of the Public Domain, but also by the Center for International Comparative Law, the Keenan Institute for Ethics at Duke, and the John Hope Franklin Humanities Center. And I'd like to thank all of those institutions for their support. I'd also like to thank Jennifer Jenkins, the director of our center, for helping to arrange this, and Balfour Smith and Erin Daniel for doing amazing work in making all of the administrative arrangements. Our one favor is, if you have your mobile phones, please turn them off so that they will not interrupt us. Our biggest thanks go to our panelists. First, thanks to Graeme for making the extremely long flight to be with us. I'm not going to summarize the extensive qualifications of our panelists. I'm only going to introduce them very briefly so that you will have more time actually to listen to them. But I'd like to welcome Sean Flynn, who's from American University, Washington College of Law, my own old school, and where he's the Associate Director of the Program for Information Justice and Intellectual Property. Lea Shaver from Hofstra Law School, who is the editor of two excellent books on access to knowledge in Brazil and Egypt, respectively, his work I greatly admire. Our own Ruth Okediji. She thinks she's the University of Minnesota's Ruth Okediji, but actually she's Duke University Ruth Okediji, who spends at least as much time as she does here as she does there, and managed somehow to get here despite a set of flight connections that were completely bedazzling to my pessimistic Scottish mind. Thanks also to Professor Chidi Oguamanam from University of Ottawa Faculty of Law, who writes very interestingly on intellectual property rights, indigenous knowledge, and agricultural claims to agricultural rights, and to Professor Molly Land, who's at the New York Law School and who has also worked as an Allard Lowenstein International Human Rights Clinic at Yale, and as a Roger Bernstein Fellow at the International Human Rights and Minnesota Advocates for Human Rights. My job is very briefly to introduce the book and our two colleagues, who are going to speak for 20 to 30 minutes, and then they will slide off to the side, and our panelists will come down, and each will speak for about 5 to 7 minutes on the book, and then we'll throw it open for discussion. But very briefly, my own take on the book. I think this book is a remarkable contribution to the field. 20 years ago, if you had said that there would be a robust international debate on intellectual property and human rights, it would have seemed about as likely as a robust international debate on dentistry and human rights, or accountancy and human rights. And the growth of this field over the last 20 years, both intellectually and in terms of activism, is certainly one of the most exciting intellectual and practical sets of initiatives that I've been involved in. Larry and Graeme have done an extraordinary service to this debate in their book. And I just want to mention 3 facets of it, which I think make it truly remarkable. The first is that there are lots of people who believe that human rights trump intellectual property, and there are lots of people who think that intellectual property is required by human rights, and that the rights of the author are required by human rights constitutions, or conversely, that somehow human rights annihilate human rights claims. Their book is much more subtle and thoughtful in dealing with these issues. It talks about the competing claims and indeed the ways in which the two discourses of human rights and intellectual property actually constitute each other, actually give meaning to each other and make each other richer. The second thing I think that is remarkable about the book is that it is truly interdisciplinary. It draws on insights from many disciplines in order to make its argument. And the third and final thing is that it's actually a book that's meant to be used. It's both a book to read and as a work of scholarship, but it's also something to be used in teaching, and that, I think, is one of its great contributions. So, without further ado, I'm going to turn it over to our two authors, Larry and Graeme. Thank you.
Thank you so much, Jamie, and thanks to the sponsors and to the panelists for coming. Graeme and I decided we would leave our remarks to be quite brief so that we could touch on some of the highlights of the book and themes in the book. And that might whet your appetite to read more, in which case there will be an opportunity for that after the lecture as well. And more importantly, because for us, this is really, the panel is having them here, this wonderful group of colleagues and friends, is to be able to engage with their ideas, their reactions to the book. They've all seen that their work is cited in the book, and it's made a real contribution to Graeme's and my thinking about this. And over the 2 years of, I would say, of intellectual engagement and enrichment, in which we never ended up actually being, I think, drafting on the same continent. We decided that we was drafted on all continents except Antarctica, but never with both authors on the same continent. So you can think about whatever you like about that. So I thought I'd start with a personal anecdote that echoes something that Jamie had said about dentistry and human rights, or that motif. And that is that when I started teaching 10 or 11 years ago, I worked on intellectual property issues, and I worked on human rights issues. And a senior colleague said to me, well, pick one. You can't do both. Those are just completely separate. You will have an incoherent research agenda. You need to change. So, and my response was, well, actually, if you look in the Universal Declaration of Human Rights, there's this funny clause about creators' rights and the rights of access to the public to scientific progress and its applications, and nobody's really thought about that. And moreover, I talk to people who don't generally talk to each other, so I learn from them that way. And that was not really an adequate response from my senior colleague's perspective, but I persevered nonetheless. And I think 10, 15 years on, as Jamie said, enormous amounts of things have changed. So what I wanted to briefly do was to kind of just to signal some of the key changes, and then to elaborate on some of the conceptual frameworks for thinking about the relationship of the two regimes, with a few examples from access to medicines and pharmaceutical patents. And Graeme will focus on a variety of the other topics, and also kind of relate his own experience in the kind of genesis of the book. So in terms of the kinds of developments that have triggered this interface, how is it possible that we went from human rights and dentistry to sort of thinking about the two fields as being interrelated? And I think I would summarize what takes up a good deal of the first chapter of the book, identifying what is really essentially the expansion of each of these two regimes of both international and domestic law. So these were largely separate silos of particular sets of legal rules, policy norms, objectives, and over time, they both of them expanded in different ways. So in the intellectual property field, the rapid expansion of IP protection standards, most notably through the adoption of the trade-related aspects of intellectual property rights agreements or TRIPS within the WTO, and then the follow-on bilateral and regional treaties, the TRIPS, so-called TRIPS plus agreements, really brought home through the expansion of IP protection standards and restrictions on exceptions and limitations, that there really was a sense in which intellectual property might be tranching on the realization of human rights in a variety of perspectives. And that, in turn, generated a response in the human rights community. It generated a response from indigenous peoples who were operating at this intersection and had been for actually some time. It generated a response that tried to articulate the human rights responsibilities of multinational corporations, which is kind of orthogonal to the traditional human rights movement, but this was in part as a result of these multinational companies themselves claiming human rights as a basis for protecting intellectual property, and in the view of many, overclaiming. So what had happened, in short, was an increasing and intersection of the two regimes, without a whole lot of time, Graeme and I thought, for reflecting on the terms of their engagement. And so I would say one primary goal of the book is to stress the inevitability of that engagement between these two different legal regimes. That is to say, there are, as we recognize, quite a number of dangers and wrong turns here, but it isn't possible anymore to keep these two fields hermetically sealed from each other. And so with that basic point in mind, trying to make that basic point, I don't think that's a difficult one increasingly to make, the normative question of how should these two regimes intersect in light of the fact that Graeme and I think they do share a set of common values, although at the margins there are many tensions between them. So what we sketch out in the book, just very briefly, are a number of different conceptual approaches. And I'll simply highlight those with a couple of examples from access to medicines and patents, and then turn it over to Graeme. So, as Jamie mentioned, one approach is to think about the relationship between human rights IP as sets of rules that are fundamentally in conflict. And you see this show up in many, many UN human rights documents over the last decade or so. And the response to that, there's a specific kind of policy prescription, and that is to recognize the primacy of human rights in international law over economic policies and agreements. That is, the rights of individuals and groups are fundamental, and they're certainly more important in this argument, this framing of the argument, than private rights with respect to knowledge goods. And with respect to patented medicines, I think you see this in the context of what was one of the salient events that most of the panelists, I think, have touched on in one form or another in their work, or extensively in some cases. The application of patented medicines to antiretroviral drugs to treat HIV/AIDS. And this massive health crisis, as it was unfolding, led to kind of the ability to frame patent protection in this area as something that would lead to the deaths of millions of individuals. And so the response was a really kind of almost visceral response: abrogate or break patents, exclude patent protection for pharmaceutical products, because this is contrary to the right to health as it was then emerging and being developed by the human rights bodies. So there's some advantages to this conflictual approach. It truly highlights the salience of the interaction between human rights and intellectual property. It puts the possibility of legal and policy change on the table in a very fundamental way, and both domestically and internationally. So I mean, I think it raised the stakes. It was sort of a necessary first step. But it has a number of serious disadvantages. So first of all, it's a static solution. If you've got the medicines available, yes, limiting intellectual property may, in some contexts, likely in others, provide a mechanism for getting those medicines to those who are in immediate need of them and whose life is endangered as a result of not having them. On the other hand, this kind of approach doesn't consider the innovation from a dynamic perspective. And if we don't have some mechanism for incentive to innovate, whether it's IP or something else, what happens when we have the next disease crisis? So that's one framing, the conflictual approach and its costs and benefits. Coexistence is the second potential approach that we outline in the book and that has been outlined by a number of scholars. And this approach essentially says human rights and IP, where they intersect, ask the same basic question: how to define the scope of private monopoly power to provide sufficient incentives to create and innovate, while also providing the public with adequate access to the fruits of those intellectual efforts. So the two regimes in this framing of compatibility are fundamentally, coexistence are fundamentally compatible, but their intention over where and how to strike the balance between incentives on the one hand and access on the other. Now, from a practical perspective, one thing that this framing does, I think very helpfully, is to have governments, commentators, international organizations reflect on the existing flexibilities and policy levers that already exist within the intellectual property regime. Things like subject matter exclusions, exceptions and limitations, compulsory licenses, special and differential treatment of developing countries, and essentially say these are underutilized, they're insufficiently invoked, and they need to be revivified. And once they are, we can make the two regimes more compatible. That is, a broader use of these policy levers or flexibility mechanisms will make the two regimes more in line with each other and intellectual property, if you will, more human rights friendly. We see some examples of this in practice: compulsory licenses in being issued for a variety of medicines in Thailand and Brazil and African countries, and of course, and perhaps most famously, the Doha Declaration on TRIPS and Public Health in 2001, identifying a structural flaw in the TRIPS agreement regarding developing countries that lack sufficient domestic manufacturing capacity, and coming up with, albeit a somewhat cumbersome solution, at least a solution that thus far is the only amendment to the TRIPS agreement, right, which is to limit intellectual property in this particular area. So very beneficial. What are some of the risks of this approach? I'll just outline a couple. So the one possibility is by using human rights as a kind of tool, that you create the possibility of external limits on intellectual property, or what I would call maximum standards of protection, which is the converse of the minimum standards that you find in the Berne Paris Conventions and the TRIPS agreement. And more fundamentally, that you are bringing into the equation deontological claims about human rights that, at least in rhetoric, if not always in reality, are about unconditional the language of trumps and unconditional demands. And so the response is, well, wait a minute, IP is evolving, it requires kind of incremental recalibrations over time, and if you are framing intellectual property issues in a human rights perspective, you risk kind of locking it in place in a way that makes it impossible to respond to evolutions in law, technology, social values, and so forth. So that's the danger of the coexistence approach, potentially. So what Graeme and I sketch out in the book is a somewhat different approach, which we refer to by a couple of different labels, but probably is best summarized as using intellectual property means to serve human rights ends. And there are a number of sort of subcomponents to that approach. And it proceeds from this kind of basic insight. So the existing policy levers and flexibilities in intellectual property regimes are, in fact, very useful for expanding the regulatory space available to governments. But what they don't do is give real guidance on how one might restructure national innovation policies and rules in a way that affirmatively promotes human rights. So what this perspective does is to essentially say, let's step back from the interface of trying to sort of determine which of these two regimes has primacy, and rather ask how can we, starting with human rights outcomes, starting with an empirically grounded approach that looks at the obligations that governments have in treaties such as the International Covenant on Economic, Social, and Cultural Rights and other agreements, to meet the right to health, the right to food, the right to education, etc. How can we then work backward using intellectual property where it is helpful and modifying or adjusting it where it's not in order to achieve those outcomes? So there are a couple of insights, I think, that stem from this, and I think it's particularly worth just flagging them in the context of what is often called the global drug gap, which is the notion, the fact, I should say, that 10% roughly of existing medical research is devoted to disease conditions that account for 90% of the global disease burden, in particular in developing countries. So there's a misalignment of the intellectual property system in that the pharmaceutical firms and go for those, devote their resources in R&D to those particular types of innovations that are likely to make them a return. And that is going to be that 10% where the market is able to bear the higher costs of the medicines that then will be used to fund the next round of research. So the human rights approach kind of steps back from this and says, well, okay, compulsory licenses and other sort of exceptions or flexibility mechanisms, those do reduce the price of existing medicines, but they don't do anything to change the innovation incentives of firms with respect to so-called neglected diseases. And also, on the other hand, even if we could direct those incentives, we've got to acknowledge that IP is not always the problem. So that the problems that human rights advocates face, or that governments face in meeting their human rights obligations, are overdetermined. They are problems in the health area of inadequately structured national health systems, problems of provision of drugs in settings where they're difficult to maintain. I mean, there are all sorts. So, and we could do this for education. We could do this for food. So, IP is sometimes a problem, but it's not the only problem. And sometimes the problem isn't IP, but it's being framed as the problem. So the idea is to be both effective and to further the right to health. Proposals to close the global drug gap should address both of its components. That is to say, both the sort of existing access problems and the future innovation issues. and that can be done by looking at it through a human rights lens and thinking about alternative ways of structuring innovation that do harness IP mechanisms, but that rewards pharmaceutical research on the basis of its impact in affecting the global disease burden. Now, I mean, there are, nicely or helpfully, there are many different policy proposals here that have been put forward within international organizations such as the World Health Organization, by philosophers such as Thomas Pogge, and by many other commentators, for different ways of restructuring innovation that achieve human rights ends, or at least could be made or adapted or harnessed to achieve human rights ends. Things like differential pricing strategies, orphan drug schemes, systems of rewards and prizes, public-private partnerships that leverage innovation capacity in both the governmental sector and the industrial sector, and so forth. So the core insight that these share, and I'll stop here, is that the strategies for achieving human rights ends ought to work with intellectual property rather than against it. So when IP can be used to achieve these goals, governments should embrace it. Where it hinders those outcomes, then its rules should be modified or restricted. But in either case, the focus remains on how do governments achieve these minimum entitlements, and how could IP be made more helpful for doing that? So I will stop there. There's much more that I could say, but I will turn things over to Graeme.
Well, thank you, Larry, and thank you to Duke Law School and the sponsors for hosting this event, and especially to Erin Daniel and Balfour Smith, who really raised the bar on showing how well these things can be done. I also wanted to take, just at the beginning, an opportunity to thank Larry. I deeply appreciate his enthusiasm for the project and his patience with me, sometimes having a squawking Kiwi on the other end of an email is often not pleasant. Co-authorship arrangements can often fray friendships, to say the least, but in large part to Larry's grace of mind and generosity of spirit, ours actually became stronger as the process went on, which was not just a product of never being on the same continent while we were writing. I also wanted to thank the panelists too, many of whom have been extraordinarily generous with their insights as the project went forward, and I look forward to the commentary that we're going to receive later. In fact, in the introduction we talk about how we look forward to the dialogue continuing and the rigorous critique we expect the book will provoke. Now that Larry's marked out some of the terrain, I thought I'd say something else about the genesis of the project. As everyone in the room will know, during the past decade and a half more, intellectual property has become an increasingly controversial topic amongst many scholars, the leaders of which are in the room, government actors, NGOs, and unaffiliated members of the public. There's been a growing sense that intellectual property rights are too strong, last too long, are insufficiently accommodating of downstream innovative activity, are just outmoded, but also that they inappropriately impede or restrict fundamental rights and freedoms. And one thing that intrigued me as a watcher of intellectual property scholarship over the last decade or so was the idea that there were a lot of normative critiques being advanced in this space that perhaps didn't take sufficient account of or didn't engage with the public international law impediments in the way of various normative propositions. So, for example, it's proposed that composers don't need the reproduction right, for example, so we should get rid of it. Yet, of course, this flies in the face of the Berne Convention, and to me, this had an air of unreality about it. But the project seemed to me to avoid engagement with the difficult cost-benefit analysis associated with withdrawing from or amending the public international law of intellectual property. You can get there sometimes, as the Doha amendments indicate. But it struck me that we needed more of an engagement that actually took account of the public international law of intellectual property when advancing those normative critiques. The other aspect of it, of course, and if you'll forgive me, I think this is an approach that one sees most in the United States, which is the idea that the calibration of property rights paves the way to salvation. And that as Larry said in his introductory remarks, the international human rights law provides a way of focusing on the regulatory space that can counter the excesses in intellectual property law. And I suspect, again, that idea comes from the background where, I grew up in a system of democratic socialism where those ideas formed part of the construction of the nation state that set a thicker discourse to respond to, or provided a thicker discourse to respond to some of the excesses in intellectual property. So it seemed to me that the overall project of constraining intellectual property would have more purchase and salience if commentators were to look to international human rights law, and that might provide a more secure normative and legal basis for some of the critiques that were being advanced. And so I started very tentatively exploring these ideas in some writings, but meanwhile Larry was producing the formative documents in the field. I also wanted to teach in the area, and this was when I was at the University of Arizona, and I went to see my dean and said I wanted to teach a two-unit course in human rights and intellectual property, and my dean very bravely said, yes, of course, you should do this, make it so. But there were no syllabi, no teaching materials and so on. And so I taught the course, and we enrolled a class that had the intellectual property crowd, the human rights crowd, and at my law school at Arizona, the Indigenous Peoples Law and Policy crowd. And we had some fierce debates, and there were students enrolled in that class that were coming to these issues and looking at them from conflicting worldviews. One of the best moments I had was when a square-jawed young man came up to me at the end of the class and said, he was in the IP camp, suffice to say, and said to me that this course rocked his world. Those were his words. Of course, you live for that moment as a teacher. But he also said he had no idea that there were different ways of looking at these issues. And my student's suggestion that there are other ways of looking at these issues captured part of what we wanted to achieve with the book, which was to explore how the lenses of human rights and intellectual property might shape the analysis of some of the most pressing issues that we are confronting. And as Larry's remarks indicate, it's not just two lenses, of course, it's a prism. And part of the complexity is that human rights law does not simply push back against intellectual property, and there's a number of reasons for this. And one reason is that major human rights instruments contain some recognition of human rights associated with creativity. So, for example, the Universal Declaration on Human Rights states that everyone has the right to the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. And as Lea Shaver emphasises in her wonderful writing, this is nestled in a statement as to the right of everyone to freely participate in the cultural life of the community and scientific advancement. So even in the articulation of human rights associated with creativity, there's the tempering of that statement with rights to cultural participation and participation in scientific endeavour. The statement about the human right to the moral and material interests of creativity is, of course, not the same as human rights protection for intellectual property, but there are nevertheless important points of intersection. The normative content of that statement has been slow to emerge. The Committee on Economic, Social and Cultural Rights published a general comment on the latter statement, which is a densely worded and somewhat repetitive document, but a few points emerge. And for what I call, for simplicity, creators' human rights are linked to the creative endeavour of the human agent, and the human rights associated with creativity are deeply connected to the full development of the human personality. And part of the evidence for that is that corporations are not the beneficiaries of this right, though the committee suggests that Indigenous groups can be. But also there's an economic dimension to this right. It's connected normatively to the right to adequate remuneration, the right to own property, and the right to pursue work of one's own choosings. And so these statements about creators' human rights suggest that the question, how does the creative worker get paid, is itself a human rights issue. And helping creative workers find markets for their works is actually something that intellectual property laws are designed to do. This is what Professor Reichman has described as the market-making aspect of intellectual property rights. So in my remarks, I want to explore these issues in the context of one of the least controversial human rights, which is the right to education. This is, of course, closely aligned to the right to freedom of information and freedom of expression. Now, copyright is, of course, one of the many inputs that affect the price of learning materials. And it seems that the recognition of creators' rights and a concern with the material circumstances within which creativity suggests distills parallels with the defining structural tension in intellectual property. And we all know that more than other areas of property law, perhaps, intellectual property law is intensely concerned with, and this is a key part of its claim to its heuristic separation from other forms of property law. It's intensely concerned with balancing incentives and facilitating subsequent access and innovation. The human rights parallel, and it's possibly only no more than that, just a parallel, is that some claims for untrammelled open access risk being insensitive to the human rights basis, to protections in respect of the work of creativity, the human creativity that goes into, in the educational context, producing those learning materials. That's part of the framework for the discussion of the problem that the most impoverished members of the human family just lack access to learning materials. A 2009 UNESCO report found that half of grade 6 students in many countries do not have a single book. Lack of access to learning materials is persistently the subject of adverse comments in country reports by the UN Committee on the Rights of the Child. And so how would you go about mapping the human rights intellectual property interface in the educational context, given that background? I mean, the analysis that we put forward in the book is necessarily perspective, but is necessarily speculative. But some of the ideas that we advance look at the claims that are made about the structural limitations of intellectual property rights and how those claims should be analysed in particular context. So as we know, the juxtaposition of copyright and the right to freedom of expression, which is closely aligned to the right to education, is often met with the so-called internalisation thesis, that copyright internalises freedom of expression because it provides the economic incentives for people to speak. And when that is positive, it's sometimes accompanied by the sense that that sort of checks off the problem with the material circumstances of creativity. A second aspect of it is, of course, is that copyright has its own internal safeguards or levers. So the idea-expression dichotomy is one of those sort of salient internal aspects of copyright that is sometimes, again, posited as a freedom of expression safeguard. Now, the problems with those theories are many and varied and have been the topic of much enlightening and provocative scholarship, some of which is by members of the panel. But I think that the interrogation of the interface between human rights and intellectual property invites analysis of whether the material circumstances in particular contexts make available opportunities for the kind of sustained creativity to, first of all, produce the textbooks that already exist. But I think more importantly, whether there genuinely exists the capacity to take advantage of the internal safety valves that are provided by intellectual property. Are there actually people on the ground who can leverage the idea-expression dichotomy, for example, to provide these alternative, non-infringing texts? And if there are not, then the least we can say is that in these particular material circumstances, the story about how intellectual property interfaces with human rights is somewhat wanting. The actual lack of capacity vitiates one of the already existing and most often posited internal structural limitations on copyright. For example, the presence in the same market of alternative textbooks. If that capacity is lacking, it also has the effect of the intellectual property right in that context becoming far stronger than even the public international law of intellectual property, the TRIPS Agreement, the Berne Convention, and so on, themselves envisage. So the hope is that by identifying what intellectual property looks like when viewed in particular contexts, opens policy spaces, opens spaces for dialogue and challenge that are relevant both to the shape of intellectual property and how the regulatory state thinks about those kinds of intersections. Importantly, this approach, and it's one of the many we explore in the book, does not imply or claim that copyright must always give way simply because its subsistence increases the price of educational works. Rather, our suggestion that we explore in the book is that the human rights intellectual property interface should invite, indeed demand, a more nuanced inquiry into the particular mix of legal, economic and political strains that exist in particular domestic and social contexts. And it's by doing that, we suggest, that we can move away from envisaging intellectual property and human rights as necessarily being on a collision course and to avoid some of the sound and fury that that collision will necessarily give rise to. Thank you.
Now we're going to ask our panelists to come up and seat themselves here.
Bring their IDs or both.
Bring your ID with you.
That'd be fine. Yeah, second.
Sanctioned severely.
Table is too small or your panelists are too large.
Speak for yourself, Sean.
It's to see how well you can all get on together. So our structure here is going to be that we're going to have a series of comments on the book and on Graeme and Larry's introductory remarks. Around 5 to 7 minutes. I am actually going to be the time fascist. And I thought we would lead off with Ruth. Ruth.
I'm going to be my own time fascist. It usually never works, so Jamie, I do need your backup. Let me just say thank you to Jamie for hosting this event and all of the sponsors, and in particular to Larry and Graeme for doing this magnificent work. You know that I mean it because I don't use that word very often. When I started, writing about intellectual property, I was fire and brimstone, actually, as my professor remarked. And for those of you who know Arthur Miller, he was a civil procedure professor, not really an intellectual property scholar. And so when I walked into his office and said, I want to write this paper for my graduating paper, and this is a system of intellectual property that at the global level has remarkable implications for a number of other regimes in international law, he sort of sat back and smiled, took his pipe out of his mouth and chuckled. That was like the only response that I got. And he said, why don't you go write it and I will read it. And the rest, as they say, is history. I wrote a paper that really needed to have this work around because at the time it really was a shot in the dark. And I was grappling with this question of whether a particular set of rules and norms that arise from a very contextualized, very historical and cultural set of assumptions really could work for the rest of the world, and indeed whether the what I would call the staticity of it, right? The fact that this was carved in canon, in statute, and codified in the worst possible way, right? The common law, which is slow to accrete, difficult to dismantle, even tougher to overturn. How would the world survive IP? I didn't really ask the question at the time, how would IP survive the world? And so when I got the call actually from Cambridge saying Professors Helfer and Austin are going to be writing this book on mapping the global interface between human rights and intellectual property, I said I wish they'd done this 15 years ago. Because I think the field, honestly, would have been very different. I think the way we think about the field, I think the way we write about the field, and more importantly, I think the way actors formally engage the field would be somewhat different. The reality, I think, is that IP scholars remain remarkably narrow. And Graeme Dinwiddie and I have had conversations about this over and over again over the years, that it is very difficult to think about intellectual property scholarship that is not fundamentally anchored in assumptions that have not been tested, that are not enclosed by presumptions that are uniquely historical, and that have failed to yield to even the most acerbic, intellectually incisive, debilitating critique that you have seen over the years, many of us have seen over the years from our most esteemed scholars, Professor Reichman, even Professor Lang, Jamie Boyle, etc. The system is remarkably resilient, and the question is why. It's a bad virus with no inoculation, no vaccine. And I think it's precisely because of the capacity of the system to reinvent itself by creating internal doctrines or ceding room to doctrines that are unlikely to invigorate political capital on the ground to expand the way in which we think about IP. So the point that Larry made about the resistance to new doctrinal limits on intellectual property on the grounds that those existing have not yet been used, I think the doctrines that exist are created particularly so that they not be used. I like to think of it as the story about folks who don't like to go to the hospital because there are more germs there than there are outside. And in many ways, intellectual property doctrine has evolved increasingly, where the solutions are increasingly found outside, but the resistance to those solutions are more and more calcified. On the other hand, as Graeme has noted, and as I was reviewing the book, both for Cambridge and some of the work that I'm doing now, human rights is remarkably broad. It's diffuse, it's wrought with explicit tension. It's a much more honest discipline than intellectual property. And that is a fundamental problem, right? In mapping this interface, and for those of you who've had the opportunity to read the book, and who will be working with the book, this is one of the first points that to me was very striking. That as a field, human rights admits its own internal inconsistency. It admits its own internal weaknesses. It's very clear, not just about the failure of human rights, but it's also very clear about the persistence on the normative value of those rights. So, you know, even though, for example, the economic rights are not often embraced or inculcated, so to speak, in institutional action, certainly not in OECD countries, that has not in any way stopped human rights advocates and institutions and policy documents from continuing to reify those rights. So the book, at the end of the day, stop or 3 minutes? I can't say 1 minute. Okay. So the book at the end of the day, mine says 1.5, but that's okay. So the book at the end of the day, I think, and as you saw in both Graeme and Larry's comments, leaves me, and I think those of us who are teaching from the book, working with the book, with this uneasy global alliance. Uneasy because the interface is clearly manageable, and that's one of the great accomplishments of this book. It does exactly what I think Larry described as establishing the inevitability of engagement between the two fields, but it is also clearly a book that tells us that we have two skittish dancers in a ballroom, both looking across that ballroom to decide who's going to ask who to dance first. The conflict hypothesis, the hierarchical hypothesis, the institutional hypothesis that the book lays out, those are my words for it, really cause a restructuring in my mind in the intellectual property field, not so much in the human rights field, because what it does, in my mind, is that it allows us as intellectual property rights scholars to think about expanding the number of actors, institutions, and interests and methodologies that we use to analyze developments in the field. And that is, there's so many things that have been beneficial about this book, but I think that is remarkable. Because IP scholars are remarkably insulated, are remarkably doctrinally rigid. You're either for limitations and exceptions or for some rights, very little in between, with the exception of, I think, Professor Reichman's liability rule regime that has traveled the world. And so for me, the sections of the book that have been the most difficult and that are reflected in both Graeme and Larry's opening comments have to do with education, with plant genetic resources, and with indigenous people's rights. Because I think it's one thing to talk about regulating private actors who produce private goods from a human rights perspective. It's quite another to regulate public actors who produce private goods, in the case of pharmaceuticals, and still quite another to regulate public or private actors that produce private goods. And in those areas of tension, I think the book sets out at least a process for intellectual property to begin to reimagine itself in the image not only of human rights as a collective of public interests that come together in a discipline, but as itself a part of a larger public international law discipline that imagines itself as actually producing an independently verifiable public good for which both human rights and IP can benefit. Thanks.
Thank you. I feel that this event, today's debate discussion, is really such a perfect celebration for this particular book because it is an extension of the project that the book itself sets out, to lay groundwork for a debate, to explore that, and to really create an opening for new thinking and new ideas about these topics. And as I read the book, I think one of the things that is so unique about it is I felt that I gained a lot as a scholar, was able to see things in new ways that I hadn't seen before. And the fact, I think, that the authors have really aimed the book to deliberately elide the perhaps false distinction between students and scholars, as the audience. It really sets up this project as one that it invites all of the readers to engage in and to think about, and says, here are the questions, very few answers offered. That's, I think, a testament to the work of these authors as scholars and as teachers, and really makes it a rare gem of a book. I want to take up that invitation to further thinking, the goal that they say to spark further debate about how the intersection between human rights and intellectual property might be conceived beyond the way that it has already been developed in the wonderful materials gathered by this book. I work on the topic of the right identified at Article 15 of the ICSCR, which talks about a right of everyone to take part in cultural life, to enjoy the arts, and to share in the benefits of scientific and technological progress. This is the same spot where the moral and material interests of creators and inventors is also recognized. And materials gathered on this topic in Chapter 4 of this book do a wonderful job first of situating the larger context of this and the poverty so far of analysis and work that has been done to flesh out what this right to cultural participation and access to scientific benefits might really mean, and also focuses on an area that perhaps that intersection and that challenge has been most developed, which is this idea of freedom of expression. How is freedom of expression in tension with intellectual property rights, particularly in the area of copyright? And what struck me as particularly interesting as I was reviewing those materials again is that what we see is an area where judges have attempted to solve this tension by avoiding it and by saying, no, there's no tension here, it's already resolved. We don't have to ask difficult questions about where to draw the line, where to strike the balance between copyright and freedom and participation, because that balance is already drawn in the law. There are already elements of this law that allow for some participation. And it's really a very conservative approach to addressing that conflict and that tension. So in my work on the right to science and culture, the argument that I put out there is for a different theory of the engagement and the tension between human rights and intellectual property. And what I suggest is that this provision, talking about the right of everyone to take part in cultural life and to share in technology, should really be understood as committed to a vision of knowledge as a global public good. And in the same way that if we have a theory of the First Amendment as operating on the sense of a marketplace of ideas as the best way to realize multiple interests in society, my vision, my theory is really a counter to that. And it says, no, the idea, the concept here is not that a marketplace is the best way to approach this, but actually this may be an area, these non-rival goods that are not naturally scarce, may be something that marketplaces are especially poorly equipped to provide. And if so, what does that mean? So I think this way of thinking about the right could offer us a more fundamental challenge to existing intellectual property law, because the implication is not just that IP is in tension with human rights in a few particular areas, at the edges, the boundaries, for example, of the right to health and pharmaceutical patents, or the right to education and access to learning materials, but that there is a more fundamental tension and problem at play in the essence of IP as saying we are going to create scarcity in order to turn a public good into a commodity and incentivize its production along a market model. Now, that conception, I think, poses a couple problems that then I have to struggle with, and I hope that some of you will take up the challenge to struggle with as well, right? where do we draw that line? And Professor Helfer in his opening remarks talked about human rights often, at least not always in theory, certainly in practice, operating as trumps. And I think that my vision cannot offer this concept of a human right to access as a trump card, right? In fact, being willing to tolerate more of a balancing may let us expand our conception of what can be rights. But what I hope it would do is to say something that we could shift the burden of justification, right? Instead of saying intellectual property protection is presumptively a good thing because Congress has willed it so, or statute wills it so, and now we'll be very hesitant to hear arguments from intellectual property or other ways of framing the public good. I think there's something to be gained by shifting this presumption and saying, well, what if we were more skeptical about intellectual property and its purposes and the necessity for it? What if we required that before you could carve out a portion of the public domain and propertize it and forbid others from using it, the burden fell on you to justify that that would be good for society? So just to conclude, I think that the challenge here that the author set up and really invite everyone in this room to participate in is a very important one, right? To think about other ways of imagining this intersection, and that is a very exciting project, and one that I hope many of you will take up the call to take part in.
Please.
So I'm going to stay seated because my notes are on my computer. So I just wanted to start by thanking Jamie Boyle and Jennifer Jenkins at the Center for inviting me to take part in this panel. I'm very excited to be here with people whose work I've greatly admired and to be a part of this discussion. So I was tremendously excited to see that Larry and Graeme were working on this kind of a text. As Ruth said, I think that there's been a great need for a book to pull together the work that's been done on the access of human rights and IP, to provide a conceptual framework and to really ask the hard questions. And I can't think of anyone better to do it than the two of them. And I'm happy to say, be able to say now that when I say Larry and Graeme wrote the book on human rights and intellectual property, I can mean that very literally. So I wanted to mention a couple of things just at the outset that I think the book does very well. It does many things very well, but I wanted to highlight two. One is that I think it's extremely comprehensive. It synthesizes and analyzes a very diverse and divergent body of literature, which was no small task. And I also think that looking at the issue of human rights across a variety of different kinds of IP helps us see the intersection of the two in important ways. We can see both common themes that arise in all of these areas, as well as the way in which different kinds of IP can have very different effects on human rights. I also think the book is extremely balanced. I appreciated that it discussed not only the problems of IP for human rights, but also the places where IP may in fact not have an effect on human rights, or may even be needed to realize human rights on the ground. And this is the protective and the restrictive dimensions that the book talks about, that in some cases IP needs to protect the rights of creators. In other places, IP may need to be restricted to allow rights to be fulfilled through other means. I thought the book was also very balanced in terms of praxis and theory, providing both a rigorous intellectual history of the activities at this intersection, but also the story of advocacy that really brought a human rights perspective to IP challenges. And also a variety of, and doing this through a variety of disciplines and jurisprudential and intellectual approaches, ranging from network theory to social movements to international relations. In terms of the ideas in the book, I wanted to specifically highlight two that I thought were really important and really helpful in approaching this intersection. The first is that I think the book is extremely useful in helping us think about the relationship between IP barriers and IP solutions. And I think this relationship is important for two reasons. First, if you think in terms of IP problems, the solutions that you tend to propose are IP solutions. It's sort of the story about when all you have is a hammer, everything you see is a nail, and that's certainly been an issue that's brought up with law in general as a solution to problems. And as the book notes, IP solutions are not necessarily always going to solve the problem. So if your concern is with the quality of genetically modified organisms, the answer may not be to limit IP rights, but rather to introduce regulation on plant varieties that helps to control any concerns about GMOs. I also think that the relationship between IP problems and IP solutions is important for another reason. Namely, that IP solutions sometimes themselves have potential human rights consequences. So in another project I'm working on, it's come up that in several places there's concerns about allowing generic producers to enter the market. Right, so one of the IP solutions that's often proposed for problems of pharmaceutical access is let's reduce IP so we can get more generic producers in there to lower the cost of pharmaceuticals. In some places, advocacy groups have a real concern about the quality of the products that are being made by these generic producers. So IP solutions may not necessarily be the solution, and sometimes they have their own consequences. So I really appreciate the book's emphasis on a contextual, evidence-based approach to these problems. I think the rigor of this kind of approach is going to help us develop very nuanced solutions that better respond to the problems we face. The second reason I think a focus on IP solutions is important is because I think, and as the book suggests, even if IP isn't the problem, I think it can be part of the solution. And this is, Larry's written about this in his article Towards a Human Rights Framework, and it's also an important part of the book in the emphasis on how IP can be made to serve human rights ends. From a human rights perspective, I think the great advantage of this is that it draws on the emancipatory potential of the human rights discourse. So I think that the human rights discourse allows us to make positive claims on the state, to affirmatively use all of the tools at its disposal, including but not limited to IP, to solve problems. So in this way, IP can be a lever to achieve a solution, even if IP is not necessarily the only barrier at issue. And I think this comes from the way in which, in my mind, human rights is more than simply a claim to negative rights, maybe even more than a claim to positive rights. It's a radical demand for the state to organize itself in a way that promotes the dignity and capacities of individual human beings. And in some ways, I think this is, I know Ruth, you mentioned this is a call on IP to rethink these issues. I think it's also a call in many ways on the discipline of human rights to rethink this. Historically, human rights has been agnostic about means, right? We want you to achieve ends. The means that we use to get there is not for us to choose. That's within the domain of sovereignty reserved to the state. I think there is a role for us to, as human rights advocates, and that's the perspective from which I come at this discussion, to look at the means that the state is using and to bring critiques such as there's an opportunity here to use IP as a lever to affirmatively achieve certain goals. The second, I think, really important contribution of this book, particularly to human rights analysis, is its emphasis on due diligence. I was particularly struck by the proposition in the conclusion that what states need to do is engage in kind of an impact assessment to identify the effects that IP might have on human rights and to develop solutions to mitigate those harms. And I think that this call is really consistent with a larger movement in human rights that includes a focus on the developments such as human rights assessment, indicators, these are all referenced in the book, the Ruggie framework, the framework established by the Special Representative on the responsibilities of corporations. These are all efforts to call for a more nuanced assessment of human rights impacts before policies are created. Ruggie focuses on corporations and their obligation to assess impacts, but I think that this book is also a call for states to think critically about the impacts of innovation policies before they're enacted. And so I think, for me, what this movement towards due diligence signals is, in some ways, a shift in human rights methodology, a kind of a fairly fundamental shift in my mind, from a focus on naming and shaming to a focus on impact assessment. So historically, human rights, our preferred mechanism for enforcement is to publicize abuses and bring shame on those who have committed those abuses. And this naming and shaming framework, I think, is inadequate for many kinds of the problems that we face in a globalized society, where problems have a number of different sources, and the way in which they work out in any individual place is very complex. So we need to move from a focus on naming to shaming to, in some ways, a focus on solving problems, right? That human rights needs to be involved in assessing impacts, working together in some instances with states to develop solutions, and that this gives us another arsenal, not that we should abandon naming and shaming, but that it's another tool in our arsenal to help achieve a better human rights goals. So I think that the issues at the intersection of human rights and IP might provide an excellent opportunity to test the merits of this new approach, which is, I think, better suited to the kinds of problems that we face at this intersection. So for those reasons and many others, which by reasons of time I won't get into, I think that this book is a great contribution, and I'm very eager to work with it in my, both in the courses I teach and in my work in practice. So thank you.
So Helfer is going to come and tell me how to turn on the So my name's Sean Flynn. I teach at American University. I also run a project that's around public interest dimensions in international intellectual property law. And that project, it functions a bit like a clinic. So in some ways, I'm a participant observer in this field. I think that, you know, through that project, working with students, we filed 4 or 5 human rights complaints around the world on intellectual property matters. And so I want to speak to you a little bit from that perspective. So we've been engaging, I think, this book very much as academics, talking about the conceptual framework that the book provides. And one of the important aspects of the book is the conceptual framework part is about like 35 pages of the whole book. The rest of it is very much engaging the overlapping of the doctrines in substance. And so part of what I want to start with is why you as a student might want to take this course even if you don't intend to be a human rights and intellectual property scholar, right? So the first reason is that engaging the conceptual frameworks is like push-ups for lawyers, right? It teaches you legal jujitsu, and it's good for you no matter what you're going to do. So getting into a new area that has 2 kind of strangely undefined overlapping fields and thinking about these conceptual issues about how they come together will help you no matter what you do. But let me shift over to the more practical reasons, which is that these fields, as we've mentioned, actually are overlapping, which means you as a lawyer, whether you're representing kind of public interest advocacy groups or corporations, people trying to protect their intellectual property, now have different forums in which you need to choose where to advocate. And that's what lawyers do. Lawyers assess forums in which advocacy can be brought and try to help their clients understand the costs on one side and the benefits of the other. So one forum might be a hard law forum versus a soft law forum, but the soft law forum may take less resources to get to the outcome you want. And you need to be able to get through those kind of solutions and advise your client which one to use. So do you go to a special rapporteur on the right to health with your drug issue, or do you try to create a new version of the Doha Declaration within the TRIPS Council? In order to help map out that strategic choice, which is what lawyers do, you have to understand both fields. What can TRIPS Council give you? Well, you got to understand WTO law to do that. What can the Special Rapporteur on the Right to Health give you? Well, you got to understand human rights law to do that. And all of these various institutions, and there's many and many of them. So one of the reasons to study this area is because you might actually use it, right? So these are, in addition to the normal reasons people pick these courses, which is because it has an interesting title, right? Has the word "and" in it. Anything that's like law and something, you're going to get to read on case law doctrine. It's always taught at a good time. It's always once a week, right? These are all also good reasons to take the course. Okay, so second big reason to take this course and study this doctrine is that it's actually happening right now. So extremely timely. There are actually processes going around the world where this happens. And first, I'm just, you know, this is the medicine story, right? The prices used to be very high. Now they're very low. Globalized access around the world, extremely important. There's a human rights dimension to that. The same thing is going on in media markets because of the globalization of intellectual property law and the monopolies that they bring. Media products are priced the same at every country in the world, whether you're poor or rich. So you may or may not care what the price of the Coldplay is. If you're a consumer advocate, you do. But what if that's a textbook, et cetera? So it brings in human rights dimensions of access to copyright protected goods. So that's why these debates are live right now, especially in developing countries. The problem with that pricing, it creates piracy, right? So this is what we hear. We need a new enforcement agenda in international intellectual property law because piracy is rampant in poor countries. And there's a critique of that, which is basically that the reason prices are high is that the system implements a legal structure that incentivizes extremely high prices in poor countries. And so now we have going on the international field two policy-making agendas. So one is called by its adherents and its analysts is the enforcement agenda. The idea is, go back to that piracy slide, piracy is rampant, so therefore we need to increase the enforcement of intellectual property rights and increase their scope and their protection, make IP rights bigger, make copyright terms longer, make patents affect more subject matter, and then on the backside make enforcement easier, so more ex parte summary process enforcement procedures, stop things at the border, allow police to confiscate goods without trials, without court process, etc. Bring it down to the consumer level enforcement. Have ISPs have a duty to cut off your internet if they suspect, that's the word, suspect you of using infringing material. Right? Allow the suits to happen at the consumer level, raise damages to a deterrent level. So that's the primary agenda in the enforcement agenda. And it's taking place in plurilateral and unilateral forums where there's no access to the text, non-participatory forums. What I call the positive agenda, some people call it development agenda, is the opposite of all those things. Take place in multilateral open forums where everybody can observe. Emphasize differentiation in scope and enforcement and minimum standards and limitations and exceptions. The opposite of what's going on in the enforcement agenda. Emphasize private enforcement, fuller due process, focus on commercial users, not consumers. Use compensatory damages, not deterrent damages. And the question is, what does human rights have to say about each of these items? And I think potentially there are strategies there. Right? So if you look at moving things into closed lawmaking in closed plurilateral, unilateral processes, that's civil and political rights. Right? There are rights to open democratic processes in international and national human rights law. So what can we do strategically there? There are some things going on. So there's a challenge against the Anti-Counterfeiting Trade Agreement in the European Court of Justice, now getting ready to be litigated. There's a letter from Senator Wyden on U.S. constitutional procedures. The social and economic rights, I think, especially appear in the kind of battle between one-size-fits-all limitations and exceptions. Civil and political rights come out, due process rights, as responses to the enforcement agenda. And then free expression rights within as we move enforcement to the consumer level, How does that back us up against the First Amendment in our country, free expression rights elsewhere? And so all of these things have real processes that are going on. These things are being litigated in international, local processes. And again, back to the starting point, your job as lawyers potentially is to decide which of these things make sense. Where can you find a human rights forum to adjudicate some of these concerns you may have? Does it make more sense to do it in a human rights forum, or should you take it in a different forum? What's the cost and benefits of that, etc. So that's where I'll leave it there. Great.
I'm sincerely honored to be part of this panel and to celebrate this great work. When I picked up this book, what occurred to me essentially was what Ruth was saying in part, how intellectual property scholarship has evolved. And as part of anybody's tradition whose work is to read books, to flip through the table of content, and I was paying particular attention to the subject of indigenous knowledge. And that indigenous knowledge is a significant part of this book. It is a testament to how far we have come in intellectual property scholarship. That the question of indigenous knowledge has completely found a comfortable space in intellectual property discourse. It's a milestone. And as Larry said much earlier, that has been a very enduring aspect of global intellectual property discourse, but it's still seeking legitimacy and is still seeking a space in all of this context. But this book's approach to indigenous knowledge has confirmed the level of progress we have made so far. But I wanted you to look at it critically a little bit more and see how each chapter speaks to, from I think it is chapter 2 downwards, each chapter will be speaking to a specific established human rights team. But when we move up to chapter 7, we talk about indigenous rights and intellectual property, which is the title of that chapter. And the question is indigenous people's rights human rights, properly so called? Larry and Graeme have tried to answer this question to the extent of their ability. What they have done is to lay out all the critical documents in international law. And they left it there for us to see whether we can truly say that indigenous knowledge or traditional knowledge is now a component of human rights, the way we can talk about access. And this book reminds me critically to the point that when we come to talk about indigenous knowledge, it is one of the greatest conceptual troubles you can grapple with in an analysis of this nature. And the beauty of the book is that it did not shy away in trying to really put indigenous knowledge in context. But then every bit of it you read leaves you scratching your head. Where do we pigeonhole this? And why is this problematic? Essentially, because when you talk about indigenous knowledge, you have to say, and they warned us, rightly so, we have to be wary of definitional obstacles. What is indigenous knowledge? Who are indigenous peoples? The reference to 300 million people scattered all over the places? Or are we talking about people in India, in Nigeria, in Congo, in the so-called third world? Are we talking about the Inuits in Canada? Or are we talking about some other people? We need to have a clear sense who are indigenous peoples. And then are we going to correspond them to indigenous knowledge? And then we talk about traditional knowledge. Is that a bigger conceptual framework that we can now use to reach out to people in the United States, in Canada, and go to Australia and elsewhere in Africa. And these are critical issues that no serious literature has really engaged. And then when we talk about intellectual property, the question now becomes, before we can seek to locate the issue of indigenous knowledge as human rights, and then we ask ourselves, is it indigenous knowledge or traditional knowledge? And why does it matter? It matters because when we talk about indigenous knowledge, and we restrict our definition of indigenous peoples to the 300 million people living in the enclave territories that continue to maintain some affiliation with the pre-colonial civilizations of which they are part. And we're talking about 300 million people, and those are the people we talk about when we talk about indigenous knowledge. And then the question that Larry and Graeme posed here was, in order to find out if indigenous knowledge could be really a direct subject matter for human rights discourse, the question becomes, is it going to be in the context of human rights or an instrumentalist economic rights under the TRIPS agreement? And there are two answers to that. If we're talking about indigenous knowledge and indigenous peoples, narrowly expressed, then the answer will be different, because we are talking about people who are under threat of extinction, whose identity, whose human rights, whose cultural survival are under threat. And therefore, any attempt in the production of their knowledge systems are all tied up with everything we know about self-determination, everything we know that are part of human rights of a people. But when we expand our construct of indigenous peoples and then look at traditional knowledge, we now spread out and reach to other peoples who are not under threat of extinction. We talk about India, we talk about Nigeria, we talk about those people that operate outside the formal intellectual property framework and are producing critical knowledge for the new global order. And when they come into the intellectual property debate, then the human rights component of it takes a second seat, because they're seeking economic leverage. They're looking at it from probably the strict TRIPS point of view. And so there are so many provocative issues in this book that I found very exciting and enriching for my own research and for my own scholarship. And another point I wanted to make, those are the two points I'll make about this book, would be when we also talk about indigenous knowledge and or traditional knowledge, howsoever called, there is always a tendency to say there is a contradiction, because we're talking about cultural exclusivism. We're talking about secrecy. We're talking about people who don't want other people to participate. And therefore, that is even discriminatory and against human rights. Anthropologists such as Michael Brown and a lot of other people have talked about that. How do we use human rights or even intellectual property to blackmail indigenous peoples? And this is one aspect of this book. If you read chapter 7 carefully, there's a lot of provocative, enlightening, and enriching literature in this chapter that I think is so fundamental to anybody who wants to engage in the issue of indigenous people's knowledge and human rights. But then, the question is, as the case in Australia, the Bulum Bulum case has shown, that the construction of rights in indigenous contexts, or even intellectual property, is different. And one of the problematics of intellectual property is actually the superimposition of a knowledge system constructed in a different economic framework upon another civilization. And that has continuously been the struggle. And so, in the Bulum Bulum case, which this book had some excerpts on, we find that, just like I said somewhere, in in the indigenous context, when we talk about public domain, in that public domain, there are many mansions. And in the context of when people say, this knowledge is exclusive to us, and this is the context under which we want to share it. And we always tend to blackmail indigenous peoples and knowledge to say, hey, it looks like you want to exclude us. Our intellectual property system is so rock solid that we have a lot of public regarding calibrations. Okay, we have exceptions. And all you want to do is to veil us with a veil of secrecy and do not allow us to participate in your knowledge production process. But that is hardly the case. One major contribution of this book is to provoke us to begin to look into the knowledge production processes and the customary legal regimes for knowledge production in indigenous circles and begin to find a way where we can redefine or reconceptualize indigenous peoples and their knowledge system in the intellectual property rights framework. And no team properly locates this more effectively than the human rights discourse. I want to congratulate the writers of this book. It has really provoked me so much so that I'm almost at the point of writing an article provoked by chapter 7. Thank you.
We're going to ask Graeme and Larry to rejoin the panel here, and we're going to open it up for questions from the audience. Bring us a chair around for you. And that's fine. Yeah. I'm going to take the chair's prerogative to ask the first question. Everyone's been very nice. And perhaps that should stop. So let me play devil's advocate. Why isn't the conclusion of this book that intellectual property and human rights should stay as far away from each other as practically possible? On theoretical grounds, the two mix very poorly. To the extent that you take the approach towards intellectual property, which both of you do, which is a highly utilitarian, contextualized weighing of costs and benefits, openness and closedness, incentive-driven utilitarian approach, it's antithetical to the language of human rights, which, as you noted, is absolute, doesn't speak in terms of utilitarian limitations, and it's oil and water. So theoretical terms, it's just that the two don't mix. In practical terms, it's actually remarkable if you look at Sean's slide, how many of those debates go on without reference to human rights. The claims against, 3 strikes, the claims against digital rights management are being made in terms of consumer interest. It's not being made in terms of human rights. It's actually interesting if you look at the access to knowledge movement, how long you can go without reference to any international instrument other than Doha. The claims are not being articulated always in terms of human rights. So as a practical matter, you have lots of people who appear to be struggling in these areas who are not turning to human rights. So why isn't this process, which you do a beautiful job of, where you articulate what I think is really a sort of social welfarist vision of human rights. So you take like a right, like education or access to medicine, and you basically say, how does the current system fail to reach the full welfare? Why couldn't you just say, people dying is bad, kids not being educated is bad. It's a social welfare analysis, not a human rights analysis. Isn't what you're doing here rather like cooking a souffle on the barbecue? It's incredibly skillful that you managed to do it, but it's easier to just do it in the oven, right? So you have proven that someone can actually do this, and wow. But, aren't there easier tools? So do we need it? Do we want it? And will it do the things we are asking it to do?
So thank you, Jamie. I just say you haven't tried my souffle yet. So, and when it comes off the barbecue, it has a certain tang to it. Tang, exactly. Let me start in a response, because that's I think a fair question. It's one Graeme and I have wrestled with, and I'll just give a couple of responses to it. So first, I think one way of conceptualizing this is to say that the framework of rights as trumps is, I think, less germane to the parts of the interface where human rights and intellectual property intersect. And why is that important? Well, it's important because if rights really are trumps at this interface, then I agree there's a problem. I mean, we really do say that you can then lock in things in a way that actually could make intellectual property worse. So it's not coincidental that the kinds of rights that relate to IP are either economic and social rights, which don't have that trumps quality from the first place, or rights that are recognized as having what ICJ Judge Rosalind Higgins called callback clauses. So they have that possibility for allowing other social values to engage. So that's one response. The second response is simply to say that you're absolutely right. And I think that the strongest critique that one can make is, do you need it, right? What does it add in terms of value? And I think there are two responses to that, some of which will draw on what was said by the commentators. One is the internal debates can very easily be co-opted. That is, you can look at those mechanisms and say, well, in principle, we have this thing called anti-competition law, and in principle, we have these sorts of levers. But Ruth goes further, and she says, these are designed to be ineffective and not be used. One way human rights can actually engage is to say, wait a minute. You've got to step outside and see that these exceptions are themselves underpinned by international legal principles and values that get omitted through the internal discourse. And the last point I'll just make is that I think you do see, you named instances where human rights are not being invoked. There are many instances where they are. And so the inevitability point, I guess, concludes here, which is that this is happening now. And we can either do it right with from a coherent framework, or it's going to be even more of a mess for both fields. So those were sort of some initial thoughts to your provocative but very helpful question.
To add to that, I mean, one of the things that got me interested generally, and this actually comes from private international law. I used to write a little bit in private international law of intellectual property, and there was scholarship that was going forwards talking about foreign recognition of domestic intellectual property policies. And I thought to myself, what is an intellectual property policy? And it seems obvious to people who are inside the baseball. This strikes me, they're not policies. Policies are about people being fed, people being educated, having sound agricultural mechanisms, people being able to participate in creativity and the development of spirit that goes along with that. That's what a policy. That's the policy space as far as I'm concerned. And so human rights provides one point of access towards saying that those are the kinds of policies with which domestic governments should be engaged. The other point, just to add very quickly to what Larry suggested, is actually as a matter of domestic constitutionalism, human rights informs the dialogue dialogues that occur at the domestic level. An increasing number of constitutional documents, even within the Western side of the Cold War framework, have embedded in them instruments that share the DNA with the international human rights movement. So even the constitutional framework within which we look at the furtherance of domestic policy has, as Larry says, an inevitability of engaging with human rights.
And just because I was being a devil's advocate, I'd add two other defenses on what you had. I mean, the first is that if you don't do it, this really picks up on Larry's point, if we don't do this, then the only human right that we'll be talking about is the right of the author to have the droit d'auteur, right? That will be the only one. But that is obviously, I think, a reductive and a bad thing. And the second thing is, I think, as the movement building point, there are people who believe that the best thing that happened to the sort of critical human rights, critical intellectual property community in the United States was losing Eldred versus Ashcroft, in which you will remember, while the one claim was Congress doesn't have the power to do it, the other claim, which the court ran roughshod over, was there's a First Amendment problem, which this goes to Graham's response. The same thing, as you know, happening in the EU. And so, in fact, I think there's actually, contrary to what my question suggested, there's actually a very direct link between at least the national constitutions, which do embody human rights norms, and the articulation of values around which social movements accrete. So I actually think, for those reasons we're very lucky to have it. But somebody needed to poke you guys a little bit. I mean, everyone was just being so nice, you know. So I think we should open it up. Julie?
Thank you all for really, really insightful comments. My question is more about the communities that have vested interests in the IP versus the human rights model. And one thing I think is really interesting about this work is, you know, you're setting out an intellectual framework for looking at the two of them together at potential complementarities rather than conflicts necessarily. And all of that's well and good, but it might be the case that there are already sort of vested interests within the intellectual property community. One of you who spoke at the beginning was, I think it was you, Ruth, was saying how no matter how much information we give them, they don't change their minds. And I wonder, you know, just looking at you guys sitting here, is it the case that there are 9 of the dozen people in the world who know both intellectual property and human rights are sitting right here in this room, you know, the extent to which that's a broader movement, and the problems that might come about as a result of the fact that the human rights community and the IP community are sort of ships passing in the night, not speaking the same language, not reading the same documents, or, you know, not using the same sorts of legal thinking. Obviously, the practitioners' communities are very different as well. I mean, here, at least in the scholarly community, you have to walk down the hall and see your colleague from IP or from human rights, and once in a while you mix at a faculty workshop. But in practice, you know, you would expect to see IP lawyers have very, very little overlap and interaction with human rights lawyers in the types of cases that they're litigating, or contracts that they're drafting, or whatever it is, that the policies that they're pushing. So one answer, obviously, is to write this book, so that you start educating students about IP and human rights together rather than as separate worlds, which hopefully influences the next generation of lawyers. But what about the generations that are already out there and the path dependencies that creates in terms of making it possible for them to start using this framework?
My first reaction would be this. Since the coming into effect of the TRIPS agreement, most of my colleagues here may agree with me that there is no institution that has exclusive monopoly over intellectual property rights. And probably no discipline within the law school that I know has migrated into other subject matters than intellectual property. And so what we find is some kind of global intellectual property order that is nested in every other imaginable area: environment, biodiversity, indigenous peoples, traditional knowledge, name it. And so when you pick up this book, it has all gone through all those arenas. And today, even WIPO cannot have a meeting presiding over intellectual property affairs and policy without people from other parts of the United Nations, the WHO, sitting in the room. And so if we would even characterize those who have already escaped from the law school as lost causes, that's not what I'm saying. No, all of us included, we are actually getting to a point. Ruth said that this book should have been written 50 years ago. If that was done then, it wouldn't have been up to this number of pages. That's the problem. So we could not think about a better time in the evolution of global intellectual property lawmaking than now, when this conversation should take place.
If I could also respond, because this is one of the questions that's really fascinated me. I'm looking right now in a project I'm working on, trying to identify places where the human rights framing has been used and where it hasn't, and to try to determine why it's become relevant in certain and sticky in some situations and not in others. So there's a sort of a historical point, and then I think from that history a point of movement for going forward. Historically, what I've found is that it's been most sticky domestically, I think in a large part because of what Graeme was talking about, that it's embedded in national constitutions. So the places where this frame historically first gets used are in South Africa, right, in national litigation drawing on national law. The interesting thing is that contrary to what we see in other areas of human rights, this norm is then uploaded, right? In other areas of human rights, we've seen norms being downloaded from international institutions, and it was actually uploaded and sparked a bunch of interactions internationally. The interesting thing is that we don't see those norms being downloaded again, right? So the statements, you've got this great bullet point list in the introduction that talks about all of these fabulous statements from the Subcommission on the Promotion of Human Rights, the High Commissioner, various bodies. That actually I found hasn't had a lot of traction, and I think that's the place where those connections need to be made. What I see going forward, what we need are more, I think, transnational advocacy networks. So comparing to, for example, the area of women's rights, you saw a lot of connection between the international and the national there because there were things like UN conferences, right, where international organizations would form advocacy networks, would connect up with local organizations, and they'd start using a common language. I haven't seen that in the area of, at the intersection of human rights and IP. The paths have been very different. International organization or IP organizations tend to do IP, and I think as Jamie was saying, if there's any document that they talk about, it's the Doha Declaration or the Development Agenda. Human rights organizations tend to talk about human rights. So we don't have the pathways that would allow for that kind of norm transmission. And so I think if we were thinking about how do we create those, this gives us a conceptual framework, and now we just need to get the people behind it. We need to form alliances and try to build that, because that's the way in which these norms get propagated, and hopefully, propagated in ways that are ultimately useful on the ground. But I think the book shows that it can be a very important framing issue, frame in a lot of different ways.
Other questions?
Sure. Well, you've all of you have done a wonderful job, and of convincing me more and more of the importance of all of this. I confess to having started out as a human rights skeptic in this area, but it is having an impact, and you guys show why. I do think the more that I think about this problem from whatever angle, and you certainly make us think about it from a number of new and different angles, at the bottom we come down to one institutional defect problem that just never goes away. You talk about transnational action groups and so on, but the fact is we have a global coordination problem that gets bigger and bigger every day. You simply do not have, with regard to the provision of public goods, you simply do not have the kind of interstate coordination, ground rules activity that you ought to have. Why that is, I don't know. You have a lot of people talking about it. You have people doing wonderful jobs. Sean is actually forming the transnational kind of group that you're doing, and it's very effective. However, it's effective up to a point, because the governments themselves don't coordinate, and they don't organize themselves to coordinate. So they come to WIPO and they pray about the development agenda, but they don't do any sort of thing of going home and actually implementing it, or trying to set up a committee among themselves to implement it. We have to have WIPO to have a treaty for the blind, access to literature for the blind. I mean, that's just ridiculous. You mean they can't all go home, make the legislation, say, okay, now we need a treaty? It is absurd. And it's the same thing with climate change. Anytime you push up to a certain point, you find this absolute lack of coordination with the provision, regarding the provision of public goods at the governmental level. And one last point about traditional knowledge, which is actually related. Having worked at the UN for a certain amount of time, I think I have enough evidence to talk about hypocrisy in international relations. And again and again, you see these governments in Geneva shedding crocodile tears about traditional knowledge, when you know perfectly well that any of the benefits that come from any of these regimes that are being set up are almost never going to go to the traditional knowledge, the people creating it. They're all going to go to the people at the top, or for devious uses. So one has to have a certain realism about how it's going to happen without ceasing to advocate for the positions that I think are actually taking shape. As someone's working on genetic resources, I think there's a lot there. But the one question that none of us can answer, at whatever side of the debate we're on in genetic resources, is how those funds are going to be distributed. And I'm very skeptical that they're ever going to reach the people who are the intended beneficiaries.
Double-fisted intervention.
Anyone want to respond? Ruth?
No, it's a question. I'm adding to his question for Larry and Graeme. So you can respond halfway, and then I'll do that.
Okay. So the provision of public goods, I mean, we've talked about this, Jerry, and you're right. And I don't think that the human rights framework solves that incentive problem, right? It doesn't. It provides a roadmap whereby if you were to get on board with the idea of providing the goods, here's the way you would do it that would achieve maximum benefit, or that would be the strongest version of the claim. That antecedent problem is a huge problem, and it is not one that I think any single legal regime, or indeed multiple regimes in combination, can necessarily solve, with one caveat. So there are some times where and I'll sort of echo one of the points that Molly made, that you can have one national jurisdiction, whether through the kind of framing of particular advocacy movements or national litigation, create a structure where one government, or maybe a handful if it happens in multiple places, begin to be first movers. And if you can leverage that, and that takes not just incentives, but it's also about rhetorical strategies, it's about transnational advocacy movements, you might be able to get to a point where it actually you get a bandwagon effect, where you get an incentive to go forward. For reasons that I think have largely, particularly the last, say, 5 years, to do with the global financial crisis, you know, doing that, making that happen, is incredibly difficult, and so that is a note of kind of realism that I think is genuine.
Let me just add a bit of evidence there, beyond what you're saying, which is absolutely right. We have an example. The German government, for whatever reasons, has thrown up to $100 million, euros, behind trying to actually help developing countries produce their own pharmaceuticals, and they've done it with people who are really good, and they're actually succeeding. And so there is an example where one government is addressing the coordination problem by actually going out and doing something, and they're really doing it. They're really succeeding.
But this is an example where you could imagine if one blockbuster drug comes out of that,
yeah,
you could see that kind of moving forward and leveraging. I mean, that said, you know, and I might say to you, go back and check if that budget is going to be renewed tomorrow or whether it's going to Greece. So, you know,
yeah,
that's
absolutely.
Ruth, did you want to? You said you wanted to.
No, yeah, I wanted to. Now you've said something that my brain is going 1,000 directions, but a couple of points that have been made that I wanted to throw back at you and Graeme for both thought and reflection. One is of course, nobody loves human rights more than those that don't have it, right? So human rights and its saliency, apart from a broad normative appeal and I think a resonance as a legal mechanism to resolve disputes, rarely comes up, other than by those who think that they either needed to catalyze public interest behind the cause, or to legitimize the cause, right? It's very rarely invoked by those who are comfortable politically, socially, economically, and even normatively by the distributional outcomes of a particular problem. So a lot of times in the human, and I saw this a little bit in the discussion, I think it was either chapter 2 or chapter 6, I can't remember now, but it made me think about this. That how do you deal with the question, for example, that assume limitations and exceptions were not designed to fail, but were designed to work. What incentives are there for people to either invoke human rights or intellectual property rights to enforce them? I mean, when Sean puts up his slide and we talk about the enforcement agenda, nobody talks about enforcing limitations and exceptions. Everybody talks about enforcing rights. And the question is why, right? To repeat, a point that I think is so fundamental, and I think Molly made this point as well. The whole point of human rights at a broader level is to put constraints on the state, and to demand from the state responses to particular social problems for which answers exist, and it's about allocating power and resources, not about making new law. Right? I mean, otherwise, all law would be a response to, whatever problems exist on the ground. So the question, I guess, is the point at which human rights gets invoked. What triggers that point, which is something the book doesn't get to, apropos Jamie's point about pushing you guys a little bit. And I thought about that. I thought about that actually when I was reading the manuscript. I thought, because I don't know the answer, but I know that it's a question that we have to ask in order to, for practitioners on both sides, to think about this problem. So Germany is giving the 100 million today. Why? We're all skeptical that it will do it tomorrow. Instead, it'll probably send it to Greece. But the question then is why? What is it? And is there a legal trigger by which somebody can say in South Africa, you gave us 100 million. We're at this point. We're about to get to the blockbuster point. You have an obligation to finish funding. Right? And I think, I wonder for me, and this is, you know, for the students and scholars in here as well, the resilience that I mentioned is we have been infected with it ourselves. Right? There is a sense in which the economics and the property rights framework, which is, I think, the part of the book that actually made me start thinking about this, and Graeme's point about democratic socialism versus sort of free market social capitalism, really sort of inculcates certain values about what I own. And when I own it, it gives me certain rights and certain obligations, but more rights than obligations when it's private, right? So there's a whole kind of structure in the debate and in the book that actually doesn't get teased out. The structure of intellectual property rights as property versus the structure of human rights as a demand upon an organized mode of government to deliver. And you know, as I'm planning to teach, with it next semester, and I've been sort of struggling with that, right? From a global perspective, this is a big issue. One last point, and that's the point, about Larry. You've made this repeatedly over the years, and I've heard Molly talk about it as well, Jerry. The notion of how discourses get kind of turned around. One of the beauties I thought of the book was, as I said, really opening the IP space to say, gosh, there are a lot more people that can be reached and that can be part of thinking about intellectual property and a human rights framework to deliver on the promise of the public interest. Because that's the one thing that I think the only field that does that effectively is human rights, other than distributional economics, which is always contested. But to say, what is this public interest for which we think intellectual property ought to accomplish? The only field that really defines it in any meaningful way is human rights, right? Yeah. Yet, to solve it and to accomplish it, we need private actors and public actors acting in concert. And human rights typically pits those against each other. And so again, it's a subtext almost playing throughout the book. And I thought, gosh, these are real structural. This is the heart. There's a pulse here that I wanted to kind of tease out today and ask you guys to maybe comment on.
That's a very wonderful set of observations. I mean, I think that one of the effects of the privatization agenda that has occurred across in many nation states is the anatomization of the people who would speak to these issues. And so instead of having established governmental agencies or public stake in agencies whose activities are affected by overreaching intellectual property owners, you have shareholders.
Yeah.
So that and I suspect, and I think this is a gross assumption about causation, is I suspect it's no accident that we have fomented about these issues in South Africa at the time when we have the job of rebuilding the nation state.
That's right.
And rebuilding those kinds of claims and responsibilities to the citizenry, and the only thing left to do it was the nation state in its rebuilt form. And so I think you're absolutely right that you have this dynamic set of tensions in the area, and the irony is that you have the best potential is probably government actors whose very activity is supposed to be curbed by human rights, invoking the human rights norms as against the private property norms that inform intellectual property.
That's right. That's right. Absolutely.
I'd like to maybe just sneak one last question in, which is one thing that struck me, and this is I was looking through some of the, in preparing for the panel, I was looking through some of the work on A2K and Lea's great edited collections and some of Molly's work and reading the work of the panelists. And one thing that I thought was sort of interesting that was missing in the human rights IP space, but was very present in the access to knowledge movement, is the idea of private hacks to solve public dysfunctions. So when Richard Stallman is upset that copyright is going to cover software and produce a negative, he doesn't write an article saying it's a bad thing, and he doesn't appeal to the international human rights apparatus. He says, I'm going to create an operating system that will be free software, and then later that gets commercialized as open source software. When MIT commendably says everybody ought to be able to get access to MIT courses, even if they can't get MIT degrees, they put all their courses online under Creative Commons licenses. I mean, Creative Commons itself was an attempt by us to actually allow private individuals to create the commons that our stupidly long intellectual property laws were denying us. And I guess the question is, to what extent is that, a lot of what you have said, I think, is what intellectual property can learn from human rights. What about the arrow going the other way? Because actually, I think, the enforcement agenda that Sean mentioned is driven by lowered copying costs and the belief that rights ought to be inversely proportional to copying costs. The lower the cost of copying, the infinite strength of rights. But lower copying costs do one other thing, which is they make international coordination of people who've never met possible in a way that is maybe one of the biggest changes in the world during our lifetimes. And so I guess one sort of final thought is that something that's maybe for edition 2 of the book, is the creation of private commonses and private networks that actually inculcate some of these values rather than appealing to states to do it.
Yeah, so I think that's a really very useful and provocative question. And I think I think one of the, I can't remember whether it was Molly or Lea that you talked about, Ruth said most of this is about what it says about IP, most of what this interface does. And one of you said, well, actually, it sort of speaks to human rights too, because as I said, it takes away, or at least it opens up the possibility of not having the Trump argument, or having it be more nuanced. And then I think the second question then is, to what extent do human rights actually become horizontally part of the relationship among private actors? And that is that is one area where, although Ruth properly talks about kind of human rights being defining of the public interest discourse, the area it has not really capitalized on is this question of what the private obligations and responsibilities vis-a-vis rights holders would be. So that's a very high-level conceptual analysis, but I think that one thing that intellectual property could teach could teach the human rights movement is how to think about going about the making human rights horizontally kind of meaningful. And maybe the way to do that is not John Ruggie's report, where he starts out by kind of saying, yes, of course, it's first and foremost all about the state, and the state should be, and then, well, maybe, you could imagine a different space in which you set up a set of norms about, so I'm thinking of, and I won't get the names right, the sort of movements with respect to free expression in the online context in China. There are a couple of consortia, right? They explicitly draw on the language of human rights in a way that I don't think they would have done even 10 years earlier. And yet none of that actually applies to them in a legal framework. Right. So, but that's one example where you could see it as a leading edge approach.
And on that note, we have reached our time, and so it only remains to thank the authors and the panelists.
Produced by Duke University, online at duke.edu.